All
Hi.
right. Okay, we're just waiting for a few more folks to join in. Thank you all for joining today's webinar. All right, then. Hello, everyone. My name is Sala Shader from the Ontario Health Coalition, and welcome to today's webinar, No Room at the Inn, Hospital Discharges, What Rights Do Patients and Their Substitute Decision Makers Have? So today we'll have Jane Meadus, lawyer and advocate from the Advocacy Centre for the Elderly, and Natalie Mehra, Executive Director of the Ontario Health Coalition, who will have this important conversation. After the conversation, we will open it up for folks to ask their questions at the end, and we will facilitate the Q&A via two means. You can either put your questions in the chat and we will respond to those, or you can raise your hand and we will call on you to ask your question. We'll repeat these instructions at the Q&A portion, but during the discussion, if you have any questions, feel free to put them in the chat as well. And to use the Zoom chat, at the bottom of your screen, there's a toolbar, and you should see a little icon that has a messaging icon that says chat. And if you click that, you can send a message, and we'll be able to respond to your questions then. And with that, I'm going to pass it over to Natalie Mehra, who will facilitate today's conversation. Natalie?
Hi, everyone. Thank you so much for being here. Okay, so this is really important. We're hearing a lot from people who are in hospital or their loved ones are in hospital, and they're under enormous pressure to be moved out of the hospital. Often they'll send in, 5 people to try and pressure the family to move the person out. And a lot of people have questions about their rights and the information that they're being given. Often now people are being pushed to go out to retirement homes or pushed to go out to long-term care homes or wait at home for a placement and those sorts of things. And so lots of people have questions about what is and isn't true, what are their rights, and that's what we're going to cover today in this webinar. And so I'm so pleased to be joined by Jane Meadus, who's a lawyer and institutional advocate at the Advocacy Centre for the Elderly. She really is the expert on these questions. So we're very lucky to have her here today. And there's a lot of kind of complex questions, and you'll need more. We're going to run through the information kind of quickly today. We're recording this so we can send the recording out to you afterwards. And I'm also going to send to you some resources that the Advocacy Centre for the Elderly has created and also that I've created to just make it easier for you to navigate some of these things and have the information. So we'll send that out afterwards to everyone who registered for the webinar. Okay, so you'll get it in your email. Okay, so Jane, I'm going to just dive right in. And so Jane is often on the journey to hospital discharge, which means being discharged out of hospital to some other setting. Could be home, retirement home, long-term care home, or other. It starts with a patient being designated often as what we call ALC or alternate level of care. Some patients might also be moved from acute care to complex continuing care units. I think people are not clear on what these terms mean. So just in order for us to have the discussion, let's just clarify what the terms are. Can you clarify, one, what is acute care in hospital? What about complex continuing care or chronic care, ALC or alternate level of care, and rehab? Can you just clarify for people what those things mean, and then we can go forward from there?
Sure. So thank you for having me today. So ALC is alternate level of care, and that means that you're ready to be discharged from the hospital, but for the fact that wherever it is you're to go is not ready. And it can also be just you're ready to be discharged from the kind of care you are into another kind of care in a hospital, and it's not ready either. So it means you're waiting to go somewhere that you're not ready for yet. And it can be, so acute care is where you're getting active medical care in a hospital, whether that's surgical or some kind of oversight or what have you. It, can be any kind of thing, but it has to be active care that requires that hospitalization for that active ongoing care. Chronic care is it also sometimes known as complex continuing care. And that's can be a unit, it can be a standalone facility, it can be beds within a hospital. But strictly speaking, chronic care is for people who are more or less permanently resident in hospital. So these are people who are not acute, so they don't have sort of an ongoing medical crisis, but they cannot be discharged to any other setting because of their complex medical needs. We have fewer and fewer of these patients these days, but they tend to be people who perhaps are not stable. So they're not acute, they don't require acute care, but they may fluctuate a lot, or they may require a lot of very complex medical intervention. They may be on a lot of machinery, ventilators, that sort of thing. So ventilator patients, for example, who live in a hospital would be in chronic or complex continuing care. Rehabilitation, again, those are specific beds, or it can be a specific unit or specific facility. And that's for people who require assistance to try to improve their care within the hospital setting. They require intensive rehabilitation. This is different from just physiotherapy. It's not the same. And it might be, for example, someone who's had a stroke who requires a lot more care um, uh, in a hospital setting, more than what could be obtained like on a ward from a physiotherapist or in the community.
Okay. So that's great. So acute care is, you've had a health crisis and they're treating you. Chronic care is that you're in the hospital for the long term because you require intrusive medical technology to live. Rehab is rehabilitating you to then be able to go on somewhere else or possibly move from acute care to complex continuing care. So complex continuing care used to be called chronic care. And Jane said we have fewer of those patients these days, mostly because they've cut the beds so dramatically and they try to move everyone somewhere else. So so when you're designated ALC, alternate level of care, so that means you could be in a medical bed, but you need rehab and there are no rehab beds available. So you're waiting, right? Or you're in a medical bed and they want to discharge you to home or to long-term care, and they've designated you as alternate level of care.
Right.
If you actually feel like your family member isn't stable enough for that, right there, or you, like that you actually really are still acute, can you appeal that designation as ALC?
So there's no appeal process specifically. It would have to be a discussion with the physician or the team. Sometimes people will talk to, for example, the patient experience or the patient ombudsman in the hospital if they really believe that things are not being done properly. It is to be a medical decision. And so it is a difficult thing to sort of challenge that alternate level of care designation. Now, people do go in and out. So I have lots of clients who are ALC waiting for long-term care, who then something happens and they become acute, so they're no longer ALC, and then they go back and forth. So it's sort of fluid, but again, there's no appeal process because it's a medical decision. You're certainly entitled to get a second opinion. That's difficult to do, but it is possible. And if you wanted to do that, again, it would be you're trying to change a medical decision by your medical professional.
Right. And there's enormous pressure in hospitals, and it has been the drive for years now, to designate patients as ALC earlier and earlier in their hospital stay because they want to move people out, right? That's how they're managing having too few hospital beds. So this does happen where patients are designated as alternate level of care when they're still medically quite unstable. Like this comes up. And so the person who is actually responsible, like end of the day, who does the buck stop with? Is it the most responsible physician, the
It
MRP
would
as they
be
call
the
them?
most responsible physician. It potentially could be another person like a nurse practitioner if they're the most responsible. But it would be the most responsible healthcare professional would be a doctor in 99% of the cases.
Okay, so for you, if you're writing notes, the term is most responsible physician, MRP, that's what they call them. And they're the ones who are then, that's the final decision maker there. Can they appeal if they're denied rehab? This comes up
Again,
now, right?
there's no appeal process.
Yeah.
When we have clients, there's a number of different things that will happen. So rehab, it's up to the most responsible physician or clinician to sort of start that application process for rehab. So sometimes we have clients who there's nobody actually making that application. And so then you have to pressure them and ask them to actually make those applications so it can go to the rehab unit or the rehab facility, if you're in, Toronto, for example, to get them to actually look at the application. It can be on the other end. So again, it can be trying to challenge the other end saying, why are you being turned down? So getting the information from the team that's looked at the application, see why are they turning them down? And it is very complicated. So, for example, if a person has dementia and has trouble following instructions, they will often be turned down for rehab. And it's not that you can't do rehab on someone with dementia. It's just you have to break down the steps very slowly and do it in a different way. So there are some discriminatory practices within our healthcare system that are, we don't have any case law on it, but it could be challenged. Another thing that we find is rehab facilities who will not take people who are going to long-term care, or because they're saying, well, they're going to long-term care, we don't want to get stuck with them, they can't get rehab. Or if they do not have a home on the other end. So perhaps that they were living in their own apartment and are going to go to rehab and aren't sure where they're going to live after. Maybe it's going to be long-term care. Maybe it's going to be a retirement home. Don't know. But at that moment, they don't have anywhere and they will turn someone down. And none of that is legal. So sometimes it's a matter of trying to push those people to act legally. But again, whether or not you qualify for rehab is going to be a medical decision, and you have to challenge that on a medical basis.
Okay, great. And okay, the other thing that I'm finding people are very confused about, there are co-payments allowed, right? So hospitals are allowed to charge patients for certain types of hospital beds, and there's a reason for that. And it hasn't always been the case, but it is now, and it has been since at least the 1990s. So can we just clarify for people? If you're in a complex continuing care bed or a chronic care bed, there's a copay. Can you just explain that to people so they understand what that's about? So not if you're in a medical or a surgical bed, right? Not at all.
Well,
But
no, it's not as easy as
well,
that.
okay, I'm not getting into the private and semi-private. People know
No,
that.
no.
The issue is
So,
the complex continuing care.
right.
We're going to get to ALC in a minute. We'll
Yeah.
explain ALC in a minute.
So what it says is that it has to be a certain type of hospital, whether or not you actually have to physically be in, for example, a complex continuing care bed. It's not. So if you are in a complex continuing care bed, the answer is maybe, because those beds are being utilized as other things. And that's one of the reasons that I said that they're getting smaller, because it's not only that they're gotten rid of these beds, but they're also using them for things like short-term rehab, other kinds of things. So in order to charge under the complex continuing care sort of stream, you have to be designated as a complex continuing care in a bed, one of those beds, and you have to be in a specific type of hospital, which is listed in the regulations to the Health Insurance Act, and you have to be more or less permanently resident in a hospital. So if the plan is for you to go to that unit for a month, 2 months, 3 months, or whatever, and then go somewhere else, even if it's like you could stay there for a year and go somewhere else, if the plan is for you to go somewhere else that's not long-term care, they cannot charge you. So you have to be permanently, more or less permanently resident in that bed. So it really depends on what the plan is for you.
Okay, and then the fees. So
Mhm.
if you're in a complex continuing care bed and you're gonna be more or less there for the rest of your life,
Yes.
the fee for that bed is the same as the fee for long-term care, right? So you're not being
It
charged for your medical services, you're being charged for your room and board.
It is somewhat the same. The maximum is the same, but what is different is the rate reduction. For the rate reduction in hospital, it's
Can you
based.
explain what the rate reduction is?
So the
Just,
rate reduction, so the maximum is almost, I think it's almost up to $2,000. I don't have the number in
that's
front of me,
right.
but it's
Yeah,
around 2,000 now. So if you are on just old age security and guaranteed income supplement, or on, a Canada pension and OAS, and it's a smaller amount of Canada pension, you would not have the $2,000 per month in order to be able to live there. So there is a rate reduction available. And how it differs in hospital, there's several differences, but some of the main ones is that it's based on taxable income only, whereas in long-term care, it's based on net income. So if you are in receipt of guaranteed income supplement, it is not included in the calculation. So if you're only getting OAS and GIS, they would only use the OAS as the calculation. So you would spend far less in chronic care, paying the chronic care copayment. The other difference is if you have have dependents under the age of 65, those people, and if they're low income, if they meet certain criteria, they can be dependents, and there is a very generous reduction for them. And if you have children under the age of 18 at home, there can be deductions for them as well.
okay. Okay, so I just put the a link in the chat. I don't know if people know how to find the chat. If you move your cursor, you should be down to the bottom of the screen. You should see a toolbar across the bottom. It'll say things like react, and there'll be a chat with a little bubble like it is in a cartoon to speak. If you click on that, you'll see people can write questions and notes in the chat. And I just put a link there to the chronic care copayment, the complex continuing care or chronic care copayment fees from the ministry. Okay, so hopefully that's clear to people then. There are different types of hospital beds, and as they move you around, oh, sorry, Jane, I forgot. So the alternate level of care, what is allowed and not allowed for charging patients copayments?
So if you're alternate level of care, and so you're not in a chronic care bed, but you're waiting to go to a long-term care home, so you're going from hospital to a long-term care home, they can also charge you once you are completed your acute care stay. So you're finished your acute care, you're eligible for long-term care, the application has been completed, you've been determined to be eligible, then they can charge you a copayment in as long as the hospital's entitled to do that. And again, the regulations say which hospitals, but it's most hospitals. And they can charge you the same as the chronic care copayment. It's exactly the same as as what we were just talking about. So the same deductions and stuff. But you have to be going from hospital to long-term care, not to a transitional home, not retirement home, not home to the community to wait, nothing like that. And the other thing that they try to do is to backdate. So they may try to prevent you from applying for long-term care for months and months. And then when you do apply and find out you're eligible, then they try to backdate that, and they can't do that either.
Backdate your copayment, you mean?
Yes, they but cannot backdate the copayment.
Okay, so this thing about copayments, I find that people get confused because, so basically, if you are in a long-term hospital bed, so chronic care hospital bed, they can legally charge you for the room and board. That's kind of the general rule. And then if you're deemed as needing to go to long-term care and you're deemed ALC to long-term care, then they can charge you. Then there's like some details around that, but that's the
Sure.
bottom line, right? Just to
Yeah.
get it super clear for people. That isn't like new. That's not what they did with Bill 7, which is
Not
where
at
they
all.
can charge you. So can you just clarify the difference here?
Sure. So, as Natalie said, ALC co-payments have been for a long time. And again, you have to remember, just because you're ALC doesn't mean you have to pay a co-payment. It has to be ALC going directly to long-term care. What Bill 7 did in 2022 was to allow situations if a person refused a lawful discharge, and that could be it could be going back to your home, it could be going into long-term care, into a home that you didn't choose, but was chosen for you by the Ontario Health at Home, which we'll talk about. So if you refuse to a lawful discharge and stay in the hospital, it may not be possible for the hospital, just to throw you out on the street because you need medical care, and that would be inappropriate. They can charge you $400 per day. In fact, they're mandated to charge you $400 per day if you refuse that lawful discharge.
Okay, people are going to be confused by the words lawful discharge because the way
Sure.
we've described it to people forever, and this is true, is that
Mhm.
if you refuse to go to a long-term care home that is not of your choosing, so you don't want to go to that home, it's a terrible home, or it's very far away, or what have you, then they can charge you that $400. Sorry, can we just, I'm just, by lawful Jane is talking legalese when she says lawful discharge. That's not how people, can you just like break that down into
Sure.
normal
So,
people
so what
language?
we're really talking about in the long-term care sector is if the hospital says you need to go. So if you're waiting for long-term care and the long-term care home, you've made your list of long-term care homes and you've chosen them, and they say, we don't like your list. Ontario Health at Home, who does the process for admission to long-term care, they can make choices on your behalf, and you do not have to consent to those homes. And if one of those beds is offered, even if it's a bed that you don't want, as long as it's in accordance with whatever the rules are, which is mostly just within 70 kilometers, if you're in Southern Ontario, and 150 and potentially more in Northern Ontario. If one of those homes is offered to you, you're saying, well, I'm not going there. I didn't want to go there. I don't care if they chose it. I'm staying in hospital till one of the homes I chose comes up. The hospital will then charge you $400 per day.
So that's legal. So they have the right now, under that law, to override the patient's right to consent. So normally, up until then, under the Healthcare Consent Act, patients had the absolute right to consent. Can you just explain that to people?
Sure. Up until 2022,
When they pass Bill
when
7.
they passed Bill 7, you or your substitute decision maker had the authority to choose any homes that you wished in the province of Ontario to go to. And no one could change those. And this is I've been doing this job for 30 years, and for 30 years, hospitals have been trying to pressure people to add homes to the list they didn't want, but they were not allowed to do that. In 2022, the legislation was changed to allow these forced choices on people. They cannot physically pick you up and take you to a home that you don't want to go to. But if that home is chosen by the Ontario Health at Home person and you say, I'm not going, then you will probably, and you stay in the hospital, they have to charge you $400 per day
Under the law, they have to
under
charge.
the law.
Yeah,
And
okay.
it's
So
mandatory
that's the Four
charges.
Governments Act that we've been fighting because cornerstone to the idea of modern medicine is that you have the right to informed consent. And so we're going to take a step back now because there are situations in which someone else might have the right to make decisions for their loved one, right? So if someone doesn't have capacity and so on. And I just want to cover that briefly so that you understand. So we've covered the different units that your loved one might end up in hospital. So just to clarify now, who has the power to make decisions regarding your or your loved one's personal care?
Mhm.
So
So,
obviously this is complex, but what is this? Can you just clarify for people? What is
mhm,
a substitute decision
sure.
maker?
So I'm
What is a power of attorney? Sorry, just one sec.
mhm.
And power of attorney for personal care. Can you clarify the differences and how that all works so people understand?
So it is extremely complex. And here I am going to be specifically talking about long-term care, admission to long-term care only. All right.
Okay.
Um, so if you are so if you're mentally competent, and it's a decision to be made about your person, for example, admission or treatment of any kind of medical treatment at all. You get to make your own decision unless you've been found incapable. So you get to make your own treatment decisions. You get to make your own personal care decisions, admission to long-term care, if you are mentally capable to do so.
Okay.
So in the case of admission to long-term care, as part of the admissions process, if there is a belief that you might not be able to understand the information that you're being given or able to appreciate the information, so you'd be able to apply it to your own situation, they will then do an evaluation of your capacity. And the evaluation is done, it's a certain number of medical professionals that are authorized to do this. So doctors, nurses, physiotherapists, speech language pathologists, who are authorized to do that. But generally, it will probably be the person who is doing the application from Ontario Health at Home. So the person who is doing that application from Ontario Health at Home will evaluate the individual's capacity by asking a series of probing questions to determine what they know, what they understand. They have to provide information. So you're not just expected to know out of the thin air what a long-term care home is, for example. So they have to provide information and probe and, ask a lot of questions to see if you understand and appreciate the information that you need to make the decision. It doesn't mean that you have to make a good decision. It just means you're able to make that decision in a cogent way. If they feel that you are not able to make that decision, then the decision-making authority passes to your substitute decision maker. A substitute decision maker is set out in the Healthcare Consent Act, which is the legislation that governs medical treatment as well as excuse me, medical treatment as well as admission to a long-term care home and some other things. But a substitute decision maker, there's a list in that act that sets out a hierarchy. So it's like from the top to the bottom of they must go down that list of people on that list to determine who is the highest ranking person on that list to make a decision. So at the top of the list, we have a guardian of the person appointed by court, which there are extremely few in Ontario. The next person would be the attorney for personal care. So if you have made a power of attorney for personal care and appointed someone to make a decision, that person is called your attorney for personal care, and they would be the decision maker. There's then someone called a board appointed representative. So if you don't have anyone, or you maybe have a family member that you'd rather over someone else that's a family member, they or you can apply to the Consent and Capacity Board to have someone apply. That's not very common, but it's available. If you don't have any of those things, then you go down to the list of family members. So it would be spouse would be the first one, then a child or parent, and then it goes down to other relatives. And then if you have nobody on that list at all who's willing and available and competent and meets all the other criteria, the Public Guardian and Trustee of Ontario, which is a government body, they make the decision. The other kind of power of attorney that people will have is a continuing power of attorney for property. And that power of attorney has nothing to do with this. It has to do with making decisions around and managing finances. So they don't have anything to do with making personal care decisions.
Okay, great. And I just put a link to the Healthcare Consent Act for Ontario in the chat for people if you want to look at that. So now you could do an entire session like of multiple days on consent and all of that. It is quite complex.
It's
So
very
if there
complicated.
are complexities about that and people are having trouble with that, where do they go for help?
Well, it kind of depends on what kind of help they're looking for, I suppose. There's a lot of information on the internet about who the decision makers are and how you have to make a decision. That's set out in the legislation. You can call an office like ours or a local legal clinic, seek legal advice. But there's lots of information out there available.
Yeah, okay. So you can do internet searches if you're able, or you can call a
Yeah.
like local community legal clinic. And then like if they can't do it, they'll help refer you somewhere or help you figure out where to go, right? That's probably the best way to do it. Okay, so when we're talking about a patient's rights when they're being discharged from hospital, let's talk about some scenarios because I know you and we talk a lot, Jane and I, about these things. And Jane, I mean, I consult with her all the time about these cases because they're quite complex often. But we both hear from people who are being assessed as eligible for long-term care, and the discharge planners try to talk them into going into a retirement home. And so can you go through what people should know about this?
Mhm. So when people are in hospital, I would say that currently the biggest problem is not the Ontario Health at Home choosing beds for people. It is actually the hospital and the Ontario Health at Home actively trying to prevent you from applying for long-term care. That
Because the
is
wait lists are so
probably
long.
the biggest problem that we have right now.
Right. So can I just clarify, Jane? I'm jumping in, but it's because the wait lists are long and they want you out of hospital. They can get you into a retirement home faster or somewhere else, right? That's what's going on. Okay, sorry, go ahead.
So because of the lengthy waiting list for long-term care, I think we're up to about 42,000 people on waiting lists for long-term care. Homes have very long waiting lists. And so they will actively tell you that you cannot apply from hospital, that you must return home. They might tell you that in order to apply from hospital, that you have to have some approval from some higher up management person, that sort of thing. And that is untrue. If you are in hospital, you are entitled to apply for long-term care. And if the hospital won't do it, you should contact the Ontario Health at Home person in the hospital. And if they refuse, ask to speak to their manager. They cannot refuse to take the application for you while you're in hospital. So that is sort of the biggest hurdle that we run into. What they will tell you is that you have to go to a retirement home. Retirement homes, so that you know, are tenancies where you contract and purchase private care. They are wildly different. You can find homes that charge $1,500. You can find homes that charge $15,000. It
A
is
month.
pay for play. You are paying for whatever amount of care. There's usually a general sort of a base package that you're signing up for. And then, depending on what kind of care needs you have and what you want, the price goes up from there. They are not, they do have oversight by the Retirement Home Regulatory Authority, sorry.
But it's self-regulating.
But it's
The industry regulating itself.
self-regulating. But
Yeah.
the difference is that, for example, while a long-term care home must always have one nurse on, a retirement home has no such requirements. It's only what you contract for. So there's not oversight on the types of care, the amount of care, that sort of thing. It is very different than long-term care in that sense. It's also very expensive depending on the amount of care that you want. No one can make you live in a retirement home. So no hospital can make you go to a retirement home. We also have new things called transitional care units.
Okay, wait, can I just
Oh,
back up to the
yep,
retirement homes? Sorry.
absolutely.
I just want to explain. So retirement homes are not healthcare facilities. When Jane says they're a tenancy, they're not a healthcare facility. And so you sort of buy a menu from a menu of services. I do want to note, because you talked about people paying for their medical care. Nobody can charge legally in Canada, right? Under the Canada Health Act, you can't be charged for hospital or physician services. Retirement homes do break the law and charge people for stuff they're not allowed to charge people for. That happens. So I just wanted to clarify that a little bit. And
Yeah.
so we're finding that they're lying to people a lot and telling people that they should go to a high needs retirement home, whatever the hell that is. There's no legislation that defines any of these things. They're not healthcare facilities. So when they're trying to push people out and they act like a retirement home is interchangeable with long-term care, it absolutely isn't, right? And so that's key. And as Jane is noting, also key, you have the right to apply for long-term care. That doesn't mean they're going to deem you eligible, right? But you have the right to apply. That's what you're saying, right?
Correct.
Okay, then
You have the
transitional
right
care
to apply.
units are kind of a separate thing. And please go ahead. Sorry to interrupt.
Okay, so I'm going to talk about sort of the different other kinds of facilities. So I'm actually going to step back. I'm going to talk about the reintegration units.
Okay.
So some hospitals have reintegration units. These are generally housed in old decommissioned hospitals, which were recommissioned for this purpose. And these are units where people might be waiting to go back to the community, maybe getting a little bit more physio or something in those facilities before they go home, or waiting to go to long-term care. But they are hospital beds. And as I said, they are usually housed in old decommissioned hospitals that were recommissioned for this purpose. And it's where they often house alternate level of care patients, but they are hospital beds. And you don't have a choice about whether to go there because they can move you to anything that's a hospital and in their own hospital. So if you are in Sunnybrook and they want to move you to their reintegration unit at Church Street in the west end of Toronto, that's an internal hospital transfer and you have no say over it. They can put you in an ambulance and move you just like they would move you from a ICU to a medical ward. It's the same thing. You don't have
Okay.
any choices.
So I'm glad you raised that point because we had a situation where a person was in Kingston in the rehab hospital there, and they wanted to move them to Brockville, where they have a little hospital with a floor that is rehab. They didn't want to go there. But it's not amalgamated to Kingston. It's a totally separate hospital corporation, Brockville and Kingston. So that's a different scenario, right, Jane?
Correct. They cannot move you to a different hospital corporation. So you have to look to see if where they're transferring you is within your hospital corporation.
So i.e. it's an amalgamated hospital.
Yeah.
I'm looking at Brenda. So like you're in Chesley, you're in the South Grey Bruce Health Center, the amalgamated hospitals there, they can move you to any of those, but they can't say move you to Bright Shores. Okay?
Yeah.
Okay.
And so, with more amalgamations that we're having, it becomes more complicated. And in, rural places, for example, Belleville, you could be sent to, trying to think what the other hospital there is.
Well, so you're talking Quinty, right? Any of the
Quinty, so
hospitals
Quinty Health, so
in
anything in
Quinty
the
Health.
Quinty
Yeah.
Health Corporation.
Yeah.
And so, it could be in another town, but it
Okay.
would have to still be within Quinty Health. They couldn't send you to Kingston because it's not part of Quinty Health.
Okay. So I just wanted to back up to this thing. When people, if they're given wrong information about retirement homes or wherever they're trying to push them, what can people do about that? So like if they're just lying to them to get them out, right? What recourse do people have?
Well, they should be going to them. Natalie's going to be providing everyone with the document that we have and really just call them on it and say, I've, researched this. I have information from a lawyer from the Advocacy Centre for the Elderly right here that says that is untrue. And again, when you're dealing with applying for long-term care, what you have to understand is that the hospital doesn't really have any authority. The only authority it has is to refer you to Ontario Health at Home for the application. So you should be dealing directly with Ontario Health at Home. And if that person says, oh no, I can't take the application because the hospital didn't tell me to, you can say, no, that's not true. I have this information in front of me from the Advocacy Centre for the Elderly or whoever. And you have to do it. And if they don't, ask to speak to their manager.
Okay, so people may be confused about Ontario Health at Home. That is the new name for what used to be the CCACs, the Community Care Access Centers. The LINs followed those, took over their functions, the LHINS. They're the people that do, the care coordination for home care and the discharge planning for
It's
Hospital,
applications for no, it's home care and applications for long-term care, and they have
from
long-term care
hospitals.
process, yeah.
Okay, sorry, just
From
the,
everywhere, from anywhere, community or anywhere,
okay,
wherever.
but just, sorry, what you're trying to specify is from hospital, it's to long-term care, but not to
Mhm.
home care?
Oh, both, yeah, no, both,
Right,
sorry.
so, yeah, discharge planning from hospitals.
Mhm.
So, can you just clarify, what is the role of the discharge planner? So they work like in the hospital doing this job. So they're who you're dealing with often if your loved one or you are being discharged from hospital to home care or long-term care or some other service.
Well, I'm not sure I'm the right person to ask what the role of the discharge planner is. I think that probably their job description says something about assisting patients and, transitioning to the community or something like that.
Yeah.
But in my world where we're dealing with discharge, as far as I can tell, in most cases, their job is to get people out of hospital as quickly as possible.
Okay, so these discharge planners, they'll be assessing whether or not the person has capacity to
Mm,
make these
Not the
decisions.
discharge planners, no, it's the Ontario Health at Home determines capacity, not the discharge planner.
So who at Ontario Health at Home
It will be the person who's taking the application
for long-term
for
care?
long-term care.
Okay, so it'd be like a coordinator.
And there would be probably either a nurse or a social worker in most cases, who would be the case coordinator from Ontario Health at Home.
Okay, so the discharge planner then is the one who, they're not taking the application for long-term care. Will they
No.
help you do the application for long-term care? Are they
No,
the one who
it's
does it
so
under?
in every hospital in Ontario, there is a Ontario Health at Home case coordinator or more than one, depending on the size of your hospital, who is assigned specifically to that hospital. So you may have been, started an application or have an application in the community, and then be admitted to hospital. Your community caseworker is no longer your caseworker. It is the person that's in that hospital, and they're embedded in the hospital, and they usually have an office in the hospital,
Okay,
but they
okay.
work for Ontario Health at Home.
I was using the wrong word. Okay, so it's the Ontario Health at Home
Case
coordinator.
coordinator, yes.
Coordinator. I was saying discharge planner.
Yeah,
That's what that
discharge
it's
planner
not.
is a hospital-based
No, I'm
employee
talking
who,
about the Ontario Health at Home
yeah,
person. Yeah, it's the Ontario Health at Home person, and they're called case coordinators
yeah,
then, and
or
they're the
case
ones
manager,
who are
yeah.
gonna determine eligibility
They
for long-term
determine
care.
eligibility, they'll do the
Administration.
evaluation.
Yeah,
They take the application, so they will ensure that, all the documents are received. They will, if you're in hospital, they'll often will have the ability to review the chart, so that makes it a little bit faster to do the application. They'll come in usually and talk to the person, and if they're not capable, their family or the person may want their family with them to complete the information about that person, and they
yeah.
complete a computerized form. And you're entitled to ask for a copy to look at those documents after they're completed if you want, to make sure that that the right information is in there.
Okay, great. Okay, thank you. And so there's another thing that I find that people find confusing. When they're told to choose their long-term care homes, often patients or substitute decision makers are given false information to try to push them towards specific homes that have like shorter wait times, or limiting their lists, or just wrong information, period. What is correct? What is supposed to happen? So how many homes can they choose? Can the hospital tell them, oh, you have to choose from this list. You can't just choose any home, et cetera, et cetera. The common things that we hear, Jane, that people are
Sure.
misinformed about.
Okay. So I'm going to sort of give a bit of a double explanation. So if you are applying from the community, it's generally 5 homes.
So from the community means you're not in
Not
hospital.
in the hospital. So if you're
Yeah.
not in a hospital, so anywhere else, it's 5 homes unless you've been designated as crisis, and then there's no maximum. And in the community, you can of course choose any homes because that's up to you. They're supposed to tell you about the approximate waiting times for all of the homes that you're applying for and the kind of bed, whether it's basic, semi-private, or private. And all homes, just so you know, because I think this is always a bit of a confusion, all homes must offer 40% of their beds at a basic rate. So these homes, these beds are now 2 to a room for new applicants. So even if the home has, you know, 2 to a room, they have to offer 40% of those at a basic rate. And depending on the home, what a semi-private, if they have them, and what a private is, are a little bit different. But at least 40%, a minimum of 40% of beds have to be offered at a basic rate. And so you can choose, whatever, semi-private, basic, whatever. Private will often have shorter lists, so you take that sort of thing into consideration.
Okay, so
When
bottom
you're
line though, if you're not in hospital, it's 5 homes unless you're crisis.
maximum.
Right, so it's 5 homes.
Minimum is 1, because otherwise you don't have an application. So you have to apply for at least 1, maximum of 5. If they say you're a crisis, you can apply.
Okay, I'm trying to simplify. So let me just, so it's 5 homes maximum if
Yeah.
you're not in hospital, or if you're designated crisis, it's more than it can be.
However many you want.
Okay, and then if you're in hospital,
So if you're in hospital, you are automatically, and you're waiting for long-term care, you are automatically a crisis patient. So there is no maximum number. There's also still no minimum number, and there is no legal requirement to choose specific homes or homes off of certain waiting lists or short lists or anything like that. However, practically speaking, because of this new legislation, Bill 7, that came in, if you don't choose shortlisted, if you only choose homes that have, 200 people who are already on the crisis list ahead of you, if you aren't choosing shortlisted homes, Ontario Health at Home will choose homes for you. So you then have to do some balancing to decide whether you would prefer to choose a shortlisted homes that might meet your criteria, perhaps be closer to your home or be ones that you like better, or you're just going to give it all up to Ontario Health at Home and let them do it and then see how it plays out.
right,
So
so
there's some
there's 2 different things, right?
practicalities here.
Yeah. So everyone from hospital to long-term care is crisis. Technically, they tell people they're not all the time. They sort of use that threat that you won't be designated as crisis if you're not sort of malleable enough. That's not true. But the bottom line is we don't have much recourse under Bill 7, right? They can choose the home for you. So even though what you have these rights normally, they are superseded now. Right? Unless we
That's right.
break
So
down the
there's
legislation. That's what
practical,
we went to court to do. Sorry, Jane, go ahead.
and I mean, even in the community, there are practical considerations. If you're a crisis and you need to go immediately, and the home that you're choosing has 200 people on that crisis list, you're also fighting against
Yeah.
people who are in hospital for those beds. And if all things being equal, the hospital patient is going to get that crisis bed. So again, there's practicalities. Yes, you can choose one home, but how long you'll wait and whether you'll ever get admitted is a different question, because a lot of homes only have 3 to 5 beds a month.
Right.
And so whether or not you'll ever get a bed is a different question. So again, there's choice, but then there's also the practicalities.
Okay. But that doesn't mean that you just have to keel over and take it if they're choosing a home that is hideous, that cannot provide the care that you need for your loved one, that is needed for the loved one. It's a terribly substandard home, or something like that. We argue, right? Like that's what we do when we come up upon these situations as people are being pushed out. What can people do?
So they need to, arm themselves with the right information. They need to speak to them. They need to work with their care coordinator. And, if you're the person in the hospital, if you're the patient of the applicant, you get to make decisions in any way you want. If you're the substitute, you have to take in a whole bunch of criteria, which is the pros and cons and what's in the best interest of the person. Again, that can be overridden by Ontario Health at Home, but you really do have to look at the practicalities. And if it's really homes that you don't want, our suggestion is always really to try to work with the care coordinator to find us suitable homes for your person, where you can, frankly, you're probably going to end up staying in that home, whether it's the home you wanted or not. Transferring even between homes is very difficult, let's just say. So it's best to try to work with them, because if Ontario Health at Home chooses something, and it can really be something that you don't want. So you have to make a decision whether you're going to do, let them choose. And if they choose, you do remain on a crisis transfer list. But again, you're unlikely to move because you're still going to get bumped by hospital people. So it's kind of you have to make the best of a bad, unfortunate situation.
Yeah, so one thing that they might say to you is, well, you go to this home temporarily and then you can move to the home that you actually want, which may or may not happen. I mean, we do hear from some people that do get the transfer eventually, but it may take a long time, or it may, be forever, right? Or too late. Okay, so then there's just a few other things, and then we're going to open it up for questions. If I make an application for long-term care before being admitted to hospital, so I'm on I've applied for long-term care, I'm waiting. I fall and have a hip fracture, right? I end up in a hospital. Okay, then I can't go home. I need to go to long-term care. Is that application still valid?
So the application itself is still valid, and I have lots of arguments with the community care and the discharge planners about that. But those applications are still valid, but they must be updated. So you are still going to have the care coordinator redo the it's called a RI form, which is all that information, because you didn't have a hip fracture before. So you may have been able to walk and ambulate with a walker before, and perhaps now you don't, or whatever. So they have to make sure if you've had a critical change in your functioning or your situation, they have to update the RI, and the RI also has to be within 3 months. So you might have done it 9 months ago and you're in hospital, so they would have to redo it anyway. So if you're in the hospital, the application itself will be put on hold. So you're not going to get an offer that's while you're in acute care. It should be put on hold while you're waiting, and then once you're available, then the hold should be lifted once you're made alternate level of care. So you're a little bit ahead of the game sometimes for people in hospital who are having to start sort of from the beginning. But they will have to redo some of that information. They may have to reevaluate capacity, because your capacity may have changed because of some kind of medical condition, etc. So it may need an update, but it's still a valid application.
Okay, but that patient, so that even though they applied for long-term care before they had an acute care episode and ended up in hospital in acute care, still when they are trying to discharge them from hospital, if they can't go home anymore to long-term care, they are crisis, right?
Correct.
Okay.
So the legislation is very clear that any ALC patient in hospital waiting for long-term care is crisis.
Okay. So this is another common thing. I've been told that I have not been approved as a crisis admission, if I wait for long-term care in hospital. That will only happen if I go home or wherever they're trying to push me to, right? Is
We
that
call that a
true?
lie.
That's a lie, right? Okay,
That's right.
so this threat of taking away your crisis designation, very common threat,
Yes.
another lie.
Yes, that is absolutely untrue. You are, by definition of the law, a crisis patient.
Okay, so I think we've covered, well, let's just clarify this one more time, because we talked about it maybe in a bit of a different scenario. So I've been told that I'm going to wait for placement in a long-term, so I'm waiting for long-term care from hospital. And they are telling me that they can move me to a different floor in the hospital or a different unit, or to another hospital site entirely. True or false?
You can be moved anywhere within that hospital setting.
Right. So that hospital setting in plain English means your amalgamated hospital.
Correct.
Corporation.
Yes.
But not to another hospital corporation.
Not to another.
Okay.
So one of the things that we haven't talked about is transitional care units. And these are very complicated and confusing for me, as well as the layperson. So some of these transitional, they'll tell you that these transitional care units, you have to go there to wait. They are generally in a retirement home and may have a third party, often Bayshore, who is running the facility within that retirement home. They may be they are often somewhat subsidized. So you wouldn't be paying retirement home rates, for example. Some of these units are designated hospital facilities, and some of them are not. If they are designated hospital facilities, they can move you there, but you are also entitled to all your services. So we find that they sometimes try to charge, for example, people for pharmacy, and that is illegal. But there is no definition, for example, of what a transitional care unit is. And they also use that for these non-hospital beds that can
Yeah.
look exactly identical. So it is very confusing. So if you're told it's a transitional care unit, you need to ask them, are these hospital beds? And if they are, then they can transfer you without consent. If they are not, you are not obliged to go to them. And if you go to them, you lose your crisis status because they are not long-term, they're not hospital beds.
Yeah, it's a real problem, this thing. It's kind of a gray area, and I almost didn't want to go there because it's so confusing.
It
Think if
is very
people are in that
confusing, but I
sorry.
think it's important that people know because
No, 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 I'm not saying that. I was
yeah,
just
no,
gonna
it's
say,
definitely something we see all the time. And it is very
yeah,
confusing. And if you're confused, you can call Natalie or me or somebody or
I was gonna
some
say people
organization. Ask
yeah,
the
sorry.
hospital, ask the patient ombudsman in the hospital, try to find out what it is.
So yeah, I was gonna say, if someone's in that circumstance, they're probably gonna need outside help to
Yeah,
figure out what it is, because the hospital staff often won't even really know or understand what it is. Like
absolutely.
it's just, it should never have been allowed, and it's
Mhm.
become a real problem. Okay, so and then so just one other thing. So when they move you into transitional care or what have you, you might be ALC, so alternate level of care. So ALC to another destination, right? Rehab or long-term care home or home care or wherever, home. But you might also be like slow stream rehab. And I just want to clarify that because I think, a lot of people might be able to go home if they just had slow stream rehab, which is less intensive rehab for people who can't take the intensity of regular rehab. And it's supposed to be slower and give them more of a chance to kind of heal and recuperate, so that they could possibly live independently again and go home. And it's one of the things that I find that I push for people a lot because, if they have that chance, they might actually make it home again. But that nowadays we're hearing quite a bit that patients are denied rehab. Like they're saying, well, if you don't get better within 22 days or 22 sessions or what have you, you can't have rehab. Or, you won't, we won't apply for you to go to a facility that has slow stream rehab, or our hospital doesn't have slow stream rehab. Jane, can you just tell what can people do in that circumstance? Other than just argue and argue and argue with the hospital and try and get them to do it for you.
Yeah, I mean, it really depends on whether it's something your hospital or another hospital offers. And again, it's something that, they may say, oh, you don't, we're not even going to apply. And again, like with any kind of rehab, it's something you should ask to actually do the application, because we've had many cases where the originating medical team just says, no, you can't go there, without ever actually applying. So you have to do that application. And it's sometimes just putting pressure and trying to get people to go, trying to provide good information about how that person could benefit and potentially go home, for example.
Okay, thank you. Okay, so we've covered a lot of ground, and I think we've covered the most common kinds of things that we hear about a lot. Are we good for maybe 15 more minutes, Jane? And can we
Yep.
open it up for questions and answers? There's a bunch in the chat. If you have a question and you want to speak your question, now realize we only have about 15 minutes, so we can't hear the whole complicated life story of anyone at this point, but just sort of if you can cut to the chase and ask the question, it will help to benefit others too. And there's questions in the chat. So if you have a verbal question, you can raise your hand. Now to do that, go down to the toolbar at the bottom, which if it doesn't show, move your cursor and it'll pop up. And there's a react button and it has a little heart. If you click on that, a little kind of window pops up and it has a raise hand function. When you're done, you have to lower your hand again using the same button, okay? So if you want to raise your hand if you have a question, and while we're waiting for people to raise their hands, there were some in the chat. Alana, do you want to identify some of the questions in the chat? Maybe we can ask a few, and Jane, you can answer a few at a time.
Sure.
Okay.
Okay.
Thank
Yeah, so one is they're asking if someone is inpatient, usually hospitals will not apply to rehab if the patient does not have a discharge destination in the community. Are you saying it's illegal for rehab to not accept this patient just because they have nowhere to go?
So my answer is that legally, yes, we have universal health care, and that means that everyone is entitled to every part of our health care if they require that level of health care. Discharge destination is not an eligibility criteria. So if you need rehab, you should get it, whether or not you have a discharge destination or not. And I think it's illegal not to do that.
So what's going on is they don't want to take you in rehab, in inpatient rehab in hospital in some cases, if they think that you're going to end up there and not have a place to go and take up a bed, right? You know, this is not my language. This is their way of thinking because we have too few beds, right? And so they don't want to get you in the front door because they're worried about getting you out afterwards. But that is not allowed. That's illegal. Okay.
Another question is, can a patient in rehab be sent home before meeting with the Ontario Health at Home coordinator that is in their rehab center?
So the answer is yes. There's no requirement that you meet with Ontario Health at Home before home care is planned. It should be, and I think that if you are going home, this is something that I'm often telling people is you need to get that Ontario Health at Home person in to arrange the rehab, arrange your home care services, know what's coming in. But I think it's poor discharge planning. And again, if something happened legally, could the hospital be on the hook for it? If something bad happened, possibly, because it would be an improper discharge. But legally, there isn't anything in the law that says that you must meet an Ontario Health at Home person to plan home care before you leave.
Okay.
Okay.
Can we ask a few questions, Alana, and let Jane answer a few together?
Okay.
Yeah.
Yeah. Okay. Another is, if your status meeting needs haven't changed, do you lose your spot on the community waitlist just because you went into a hospital? That's one. Can you refuse a transitional bed if it is not technically a hospital bed?
Okay, let's take those two.
Okay, so if you go into the hospital, you're going to and you've already on the long-term care list, so you go in the hospital, you're just basically, you're not going to be offered a bed while you're in the hospital, and then when you return to the community, your bed is taken off of like a hold, so it should not affect you whatsoever. Again, if your needs change, usually it's for the worse, so usually it's not going to make too much of a difference. The only potential would be that a home might look at that application and said, well, you were in this kind of condition at this time, but now you're much heavier, and we don't provide certain services that we can't provide, and refusals have to meet certain criteria, but generally you just stay on the list and go along.
Yeah, so like a long-term care home could refuse a placement if they say
they changed
provide the complexity of care that
yeah
needs. Yeah.
And with respect to transitional beds, if it is not a hospital bed, the hospital cannot force you to go to it.
So there's this silly gray area that has grown up, and almost no one knows whether or not those are really hospital beds or not. That's the problem. But yeah, I think you might need outside help in that situation. Okay, any others in the chat?
Yeah, I'll just maybe do two more because of time.
Okay, and please raise your hands if you have verbal questions. Otherwise, we'll wrap up once we've gotten through the questions in the chat.
Okay. So does the list include information about how many community and how many crisis designated people are waiting for each home? What
No.
about patient advocates / navigators to assist in determining what's best for the patient?
Right. So the information that they have to provide you is approximate time to get in. And that's a really difficult thing for them to do, but it does not tell you who's ahead of you on the crisis or community. So how many you're on, and there's a very complex list of categories as to who gets beds above everyone else. So you have to, for example, just so you know, you have to get through all of the crisis patient beds before you go into sort of the regular category beds. And crisis, again, it doesn't matter hospital or community, it's by need. But the directions to Ontario Health at Home are, if everything's equal, it goes to the hospital patient. So you're only just entitled to know approximate time, waiting time. And that's extremely difficult to do today. You take it with a grain of salt, but they'll provide that information. Patient advocates, patient navigators. I mean, there are people in the community who do provide that service for a fee, and people do use those people. I don't know that there's a huge number of them around, and I'm not aware. I mean, there are some agencies who, have some ability to assist people who are low income. So if you have a social worker or something in the community, they might help you. Again, it's sort of there's not a really great system of patient advocates in the community at the moment.
Yeah, there's really very, very little. It's a problem for sure. So I just put a list of community legal clinics in the chat for people. And then there's ACE, the Advocacy Center for the Elderly. Maybe Sala, do you mind putting the link for ACE's website in the chat as well? Obviously the Health Coalition and local health coalitions can help out a bit, and usually they'll end up calling us and we sort of, help walk through things. Yeah, there's not a lot. In the mental health system, there's more, but yeah.
Yeah. And so we'll provide some information in cases, and it's depends on a lot of different things. Whether we offer any kind of advocacy, again, will depend. We offer only to low-income seniors. And if the senior is incapable, we may take instructions from a substitute. It depends. It's a case-by-case basis. But again, we determine, so it's not just because you call. If you call, we'll send you the document that you're going to get from Natalie. But whether you get anything else, it really depends on the situation. So I just want people to know that.
Right. Okay. Yeah. So we can't sort of promise the sun and moon and sky, but everyone does everything they can. Okay. Any more questions in the chat? So I think that the repeated questions for lawyers, it's actually very difficult. We can't really recommend individual private lawyers, from the Health Coalition. That's not, I mean, there are like malpractice lawyers. You can find them online. You can find lawyers, some kind of healthcare lawyers. But anyway, I've given you the list of the clinics.
And I think the other thing too is that, you need to make it known to your local MPPs that you're not happy with the system and the way things are going. I mean, that's really where, a lot of this is political. And a lot of what's said by politicians, they say one thing and then they do something else behind the scenes. So I think it's really trying to put pressure on the government to make sure that the system's fair to everyone. It's a big mess out there right now, unfortunately, in long-term care.
Yeah, it really is terrible. Okay, any other questions, Alana, in the chat?
Yeah, there are just 3 more. I think we should be able to. Yeah. So one is, there are news reports that there are 5 patients who have been fined thousands of dollars each because of Bill 7. Are there any legal avenues for these patients to recoup their money? Another is, what is the criteria to charge the per diem rate? And multiple people have asked where we can find a recording of their presentation.
Where we can find, sorry?
A recording of the presentation.
Okay, so I'm gonna deal with number 3. So this is being recorded and we'll send the recording and links to resources that would be useful to everybody who registered for this Zoom. So we'll send it by email to you, so you'll get it. It'll take us maybe a day, maybe it will probably be by Monday, I'm afraid, because we need to get up the recording on YouTube and things like that. So give us till Monday, but it'll come out to you. And then this issue of Bill 7. So Jane, it's a simple answer.
So the answer is that the criteria is that you have been discharged and refused to leave the hospital. So it isn't specifically to only people who are refusing long-term care beds. It's a broader than that, but you know, if you refuse a bed that's offered to you from your list, whether you chose it or whether the Ontario Health at Home person chose it, and you remain in hospital, you are going to be charged $400 a day. Just so you know that prior to this legislation, hospitals were charging in similar situations, and it was like, could be $1,600, $2,000 a day. So it wasn't that it wasn't happening before, but what we didn't have before was the ability of Ontario Health at Home to choose beds for people.
Okay, and if you don't mind, I'm gonna rephrase that in like from the patient's point of view. So if you refuse a placement that's inappropriate, like to a place where you don't want to go, it's substandard, it's too far away or whatever, and they charge you that $400 a day, no, there's no recourse. That's what the law is. That's the law they passed. That's the problem. So we
But-
appealed that in court. We're waiting for the ruling by the judge. We brought a charter challenge against that, saying, you know, it targets elderly patients in a way that no other patient is targeted. So it's discriminatory. And it's a threat to the life, liberty, and security of the person, right? Those parts of the Constitution. And so we're waiting now. We've argued that in court. We're waiting for that ruling. And
Right.
I'm just going to be shameless here. We have to pay, it's going to cost us more than $200,000 for that charter challenge. So if anyone wants to help with our fundraising for that, we obviously have not raised enough funds to pay for it, and we have to pay for it. So if anyone can help, that would be amazing.
So yeah, so the charter challenge is with respect to the choices of the homes done by the Ontario Health at Home, so taking away the ability to consent. With respect to the fees, you know, first of all, it's going to be charged by the hospital. The question of whether the hospital will be able to collect is a different question. So if all the person has is old age security, guaranteed income supplement, government pensions, RIFs, that sort of thing, anything that's pension related, those are non-garnishable. So in order to collect the money, the hospital has to sue and win. So it was a bill, they could send it to collections, and they can sue you, but whether they actually can collect, you can't get blood from a stone. It could be if they sued and you died, it would be could come out of your estate, for example. But you know, they would, you know, if it was a lawsuit, you could try to fight it there. They cannot, the other thing they do is they sometimes try to charge the substitute decision maker, the attorney, personally. They can't do that either. So it's a charge to the person. So we haven't, in my knowledge, haven't seen any hospital actually sue anyone to collect. So those charges are on the books, whether people are paying them. I do know of some people who have paid, but whether most people are paying them and whether they're actually able to collect the money is a different question.
Okay. So that was all of them, right?
I think so.
Wow. So, Jane, you're amazing. Thank you so much. I tell you, Jane is so generous with her time. You know, we'll talk at night, we'll talk on the weekend, we'll talk early in the morning. You know, she always stops and, you know, gives me the info I need and listens to the stories, and, you know, she's just amazing. And so we'll help in every way we can in these circumstances. It does get very complex. If you're from a local health coalition and you have members out there who need help with these things, we can kind of help to train you to help people, because obviously no one person can deal with just the wave of need that there is in this. We'll probably do another webinar down the road if people want, like another one like this, because there just are so many people who need this info. And Jane, I just, from the bottom of my heart, thank you so very much. Also to Alana and Sala, our staff people who make everything work. You guys are amazing. I hope this
just
was...
wanted to
Oh,
I
sorry.
saw a question just come up that I did want to touch on just a second. You're
Sorry,
welcome.
Jane. Go
I
ahead.
know this is very complicated. That's why that document that you're going to get is so lengthy, because it hopefully will explain it and you can look at it and get the information that I provided today. But someone asked it whether they could sue and take assets like equity in your home. And absolutely. So if they sue you, they could put a lien on your property or try to get assets that way. If you had non-RRSP kinds of assets, yes. So, or non-government funded assets, pensions and things like that. So there are things, if you have money, if you have assets, absolutely they can sue and go after those, just like any other kind of
Right. So your
lawsuit.
pension,
So I just wanted to make sure you know that. So
your
pensions and
pension
stuff are
income is
non-garnishable.
safe.
Pardon?
Sorry, so you were trying to clarify your pension income is safe,
That's
but
right.
not
Your
your
assets.
other assets.
Right.
Okay. Okay. Okay, everyone. Well, thank you, Jane. Send you a giant hug. Okay, and take care, everyone. We'll end this session now. We can end the recording. Can we save the chat?